is that cat?
Archer.
You just gonna stare at me?
Oh.
I am Walrus. What the hell?
What's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy to have you guys on here. Happy Tuesday. Apologize for not being on Monday. Kind of going through some things with work and personal life and all that. Don't want to get into it, but I do my best to try and keep the stream going. I do have a couple of announcements to make. The first being that, the big breaking news that I only just got maybe a couple of hours ago. Kim Gardner has resigned as of today. Instead of waiting until I think it was June 1st, or June 6th, I can't remember. She has turned in a resignation effective immediately today. So that was actually kind of not expected, but it does also appear that the county attorney's office will be handling the transition at the St. Louis Circuit Attorney's Office. So hopefully they will be able to get things going, and so that St. Louis can actually prosecute cases. So that's the first bit. Second bit of news that's also kind of personal. For those wondering, my replacement GPU is allegedly on its way. I got a tracking number. It's supposedly coming in on Friday. We'll see if that actually pans out. My prediction is probably it won't be here until Saturday, but there's that at least. It's something. Then I think that's it. Oh, so yeah, that's it for the breaking news. The what we're talking about here, our Nevada judges, shout out to them, have released an update for the case with Roger Hillygus. If you guys don't know, the Roger Hillygus story, what's his face? He was accused, him along with his buddy, which is I can't remember his name. Henty. He, him and I attempted were allegedly kidnapped his mother and went all the way to California. And that's what they're charged with. They're charged with kidnapping of their mother from an assisted living home. While Henty is not in the hearing since they were apprehended, Henty has not really gone full sov sit. He's kind of like wavered, but as far as I understand, he does have legal representation. If that he may be going self-represented, but so far he hasn't exhibited full-on sov sit stuff. Roger Hillygus, however, has gone full sov sit. Roger Hillygus is full-on sov sit as you're going to find out here. Again, if you want to know the deep dive into Roger Hillygus, Mandy will put a link in the description of our of the stream. Of the stream, and you will be able to take a look at the deep dive I did on this situation. But we're going to take a look at this. We're not going to get through the entirety of it. It's about an hour and 18 minutes long. There's a lot of like dead air and a little bit of boring bits, but so we're going to try and skip through that. But we're only going to go through about an hour's worth of it, or not even an hour's, for maybe about 30 minutes to 45 minutes worth of it. So that said, let's get started. Yeah.
All rise. Second Judicial District Court, the state of Nevada is now in session. The Honorable Barry Bozo presiding.
Thank you. Please be seated. May have jumped the gun a minute or two, Mr. Stiggy. My apologies.
Thank you. I'm sorry.
Okay, good morning, everyone. We are on the record in the case of State of Nevada versus Mr. Hillygus and Mr. Ante. Case number is CR 19-1535A and B. The court recognizes Mr. Stiggy, prosecutor, on behalf of the State of Nevada. Mr. Prasad, standby counsel for Mr. Hillygus. Good morning to you both. Mr. Ante, his counsel, Mr. Silverberg. Good morning, Your Honor.
Good morning, Your Honor. And I'd like the opportunity to address the court as I did last time, if quarter two.
Possibly. Please have a seat.
Thank you.
Put it on the agenda.
I would also like to address.
That's all. That's Hanty, and this is Hillygus.
Thank you, Mr. Hillygus. That's, again,
I guess I completely missed that both of them are there. Maybe Hanty does go back soft set. I don't know. We'll see.
that may happen. I have to see how we're doing today.
I think we have the whole board to set aside shows. Track.
You know, Mr. Ante, we're going to talk a little bit about comments you made in front of the Board of County Commission and how that relates to your pretrial supervision. But you don't want to put the court in a more concerned mood than it already is. So let's just wait until I call on you, and then I'll decide whether you'll be heard. That's how we're going to approach this today. Now, first order of business. I want to talk about Mr. Hillygus' competency evaluation. We have the one which really was a non-evaluation with the default position from a month ago that because no active engagement occurred, the evaluator decided to their reading of the statute that it would be a finding of competence. We did not have the second evaluation a month ago. I don't see that one was filed, of course, so Mr. Prasad, what's the update, please?
So, Your Honor, as I touched upon last time, the issue here is we have a contract, the county has a contract with NAFCARE.
Yes.
So we're forced to go through that contract, get the evaluation done. Mr. Hillygus is one of many cases where it's still pending an evaluation at this time. I have reached out a few times, my office has, specifically on Mr. Hillygus' case to try and see when the next evaluation is. Based on the responses I've gotten, none have been scheduled yet. My suggestion to this court
Hold on, let's just stop there. None have been scheduled yet.
the second evaluation is not been
Is
scheduled.
there something this court can do to move it forward?
So my suggestion to this court is its last order on this indicated a strong preference for an in-person evaluation, which we included in our evaluation referral. I would suggest that we update that to a mandatory in-person evaluation because the most recent response we received from NAFCARE is they're attempting to set up their telehealth equipment, which is causing the delay, as I understand it. So I think if this court would amend its order to require it in person, we can update our referral to that. I don't want to sit here and guarantee that'll make it go faster, but I think that will help speed the process up.
They have an office here.
I am unaware of where their office here is.
Mr. Stiggy, I'll hear from you in a minute. Would you please sit down? I'm aware that there's a side of the state you'd like to explain.
Okay, so it sounds to me that they tried to get an evaluation. It was unsuccessful. It kind of sounds like Hillygus decided not to participate. The defense attorney says that they are trying to reschedule, but he wants the order requiring the competency evaluation to be done in person with this contracted organization to help speed up the process. Because I believe this one they are trying to reschedule it for another telehealth thing, which I think both you, me, and everybody else will probably say that Hillygus won't participate in it at all. He ain't gonna show up. So
in person, as in if he's in the jail, they go up there. If he's out of custody, which I want to talk about his custody status this morning, he goes to them.
That's correct, Your Honor.
Because right now the order is gray and it allows for a possible virtual consultation, and so they're not in giddy up mode to get him in person because the order doesn't so direct.
So that's my understanding. The most recent order was a strong preference. We put that in our evaluation referral that the court has a strong preference, just these evaluations.
Well, let me tell you why I had it. I'm just reflecting back. One of the reasons that I directed it in that fashion was I didn't want the in-person piece to delay things. So if the best we were going to do to get an efficient, comprehensive, accurate, timely evaluation involved virtual contact, the court would hold its nose and allow that. I didn't realize for a moment that the faster way possibly would be to order in person. It sounds like that might be
It might be the faster way, Your Honor, because again, the most recent update we received from NASCAR and reached out specifically on Mr. Hillygus' case, which I believe was about 2 weeks ago. We did reach out last week with no response as of yet. But the response we received 2 weeks ago was that they're working on setting up their telehealth equipment.
As in, we're working on that direction.
That's my guess.
Let me, before I hear from Mr. Steggy, let me move to Part B here. And Part B is, I don't want Mr. Hillygus lingering in the Washoe County Jail. We know he fled. We know he was brought back. We know we have concerns that he won't engage and follow court orders. That's why he's been in jail all this time.
yeah,
But he's lingering. He appears to be deteriorating. At least his physical presence appears to be not as strong and vigorous as it has been in the past hearings. I would consider strongly an option where if the defense presented in writing within the next day or two, I would get you all back in here Thursday morning of this week to discuss circumstances where Mr. Hillygus could be let out of the Washoe County Jail to house arrest with some type of anklet tracking to make sure we know his whereabouts. And then he'd have to stay at home and wait for this. As long as I knew, and pretrial services knew where he was going to live and if with someone else, with who, as long as he...
again, I haven't seen this from start to finish, so I don't know the end result. But this is not a good idea. Yes, his health is deteriorating, but the judge said it himself, and I think the prosecution is going to say it themselves. This dude's a flight risk. He already tried. The whole point of this is he tried to leave the state.
He understood he would only be allowed to leave the home to go to church if that's his thing, medical care, meet with his attorney, food, things like that. He can't just socialize and go out and about. And that way he's out of the jail and he's back in a more comfortable place, so he can hopefully regain some of the strength that he appears he may have lost while he's up at the jail. I would consider that. Of course, we would need a hearing. I would need something in writing on what the defense would propose, pending the in-person evaluation. Because I'm not for keeping Mr. Hillygus in jail while we go through these competency proceedings. We all are aware of the well-known axiom that punishment follows conviction if any does not precede it. And from where I'm sitting, Mr. Hillygus has been in jail a long time awaiting the evaluations. Granted, he's the one who left the state, he's the one that caused delay, and so there's a mode of thinking that this is a product of his own doing.
Yes, yes. He's the part of the reason why he's in jail. Why he hasn't been let out. It's his own actions. But all right, I better hear a good argument coming from the judge.
Nevertheless, I don't want him lingering in the jail. And if you said, Judge, he's going to be evaluated next week, they're coming up to the jail to see him, we don't have a meeting this Thursday morning, but we don't have that. We have a menu order, make it clear it's in person. That might move it up a little bit, but even that's a bit uncertain. Do I have that right?
That's correct, Your Honor.
Okay. Mr. Hillygus, you're standing up like you want to address the court.
I'd like to object to everything that you just said, because your
Mr.
order,
Hillygus,
your order was null and void.
Oh my! And here we go. Here we go.
Because I
Mr.
challenged your
Hillygus,
jurisdiction.
that's enough,
And
sir.
you've lost jurisdiction.
Jurisdiction.
Mr. Hillygus, I'm only going to ask you this one more
I
time. then I have the
filed
deputy.
3 motions, writs, with
I'm aware.
challenging your jurisdiction.
I'm aware of that, Mr. Hillygus, but right now I need you to sit tight and let me do my thing here. Mr. Steggy, on the issue of how we, well, the one approach that the court is being asked is to amend its order to direct in person. Second thing is, you've heard the court's concerned about Mr. Hillygus staying in custody while this process plays out. What are your thoughts on either of those, or things related?
Okay, they have a contract with an organization to do evaluations. The court ought not to jump into that fray.
Well, hold on.
As well.
By ordering it in person, am I jumping into that fray?
Well, if they have a contract that says that it's permissible to do telehealth evals.
Unless otherwise ordered by the court. They wouldn't sign that contract if the court thought that it would benefit from an in-person evaluation.
Well, in any event, the court should not forget that this is on the heels of not 1, but 2 separate evals where Roger Hillygus has failed to cooperate.
True.
The first one was telehealth, and he went on with this sovereign citizen nonsense with him.
Yep.
And prevented it from
Excuse me
happening.
1 second. Mr. Hillygus, please have a seat,
I
sir.
would object that I did not.
Mr. Hillygus,
It's on the record that I've objected to not refusing to cooperate.
And Judge, if he does that again, I'm gonna ask you to take action. This whole proceeding has been marked by the defendant, Mr. Hillygus, as well as Mr. Henty, interrupting the court and acting as, see?
So, gentlemen, it's tough to sit in court and listen to people speaking about you, your behavior, your actions, your beliefs. I get it. And oftentimes, in this type of an adversarial process, feelings are hurt. People take offense at the way somebody else looks at the system, the process, what their actions constitute. But you can't just jump up and speak whenever you want to. It doesn't work that way.
When there's
If you-
falsehoods being said, I object to perjury and falsehood being made against me. I object to those.
I need you to be quiet, please. If you
Perjury.
continue to do this, I'm gonna have the deputies remove you, bring you downstairs to the law library where we can turn on maybe a feed so you can watch the proceedings here.
Give him the old Judge Duro
I'm
treatment.
not gonna let you stay in the courtroom. I need you to be respectful of the process, even if you don't like it, and even if you don't like what you're hearing. I mean, believe it or not, at this point, we're trying to get our feet under us of whether you can represent yourself. And if you can, then I will allow you to be heard, to make objections to things that you have basis to object to. But we're not there yet, all right? So please have a seat. Right now, I want to find a way to get you out of the jail. If there's a way to do it that protects the community and make sure you're going to get evaluated. All right, go ahead.
So, he's been uncooperative with 2 evaluations. He ought not to benefit from that. This hearing, I'm prepared to, I want to do 2 things with this hearing. Number 1, I wish to challenge the present situation where the defendant is even in competency proceedings. I don't think there's cause to believe that Roger Hillygus is presently incompetent. I would do that by way of testimony from Dr. Loring.
So I think that the prosecutor's trying to give the, which I think is a fair argument, because a lot of times, the prosecutors who know who sovsits are, they know that sovsits aren't incompetent. They're not insane. They're just morons who believe in idiotic things. Being a moron and believing idiotic things does not make you incompetent to stand trial. It just makes you a moron. But incompetency is supposed to be, you got to be lucid, aware of your surroundings, and capable of understanding what's happening. Him making these BS pseudo legal claims does not make him incompetent, and I think a lot of courts have called Sovsits out on that.
As to her evaluation and interaction with Mr. Hillygus. The idea that the court is desirous of letting Mr. Hillygus out, I think that is a mistake. I mean, looking through the factors to be considered in our bail factors, flight, it's concerned with flight. We have 2 instances of flight. I mean, we can get there. I know we can get there. I'm happy to argue that, but for today's purposes, this continued and deliberate sort of obfuscation and delay.
It should make them incompetent to represent themselves? No, that courts have upheld, because here's the problem. They'll, and I've seen this several times in cases where folks do represent themselves and try the soft sit thing. They fail miserably, but then on appeal, they'll try to make the argument, oh no, I was actually, the judge should have ruled me incompetent. And the court's like, no, you knew what the charges are. You asked questions, you made briefs. Yes, they are full of gobbledygook and nonsensical pleadings, but you knew what the circumstances were. We're not going to give you an out just because you believed in a BS legal theory that holds no weight. You knew what the consequences were. So we're not going to give you this out that you should have been ruled incompetent just because it didn't work for you. Now, bear in mind, it's not all the case. Sometimes there are individuals who buy into the soft-sit thing who actually are incompetent. Like, they are actually, like mentally slow. That's the better way of describing it. They're slow. And it may be that they were in fact incompetent, and they were just led on by some grifter, right? But a lot of these folks, no. Dale Brooks was not incompetent. He was just an idiot and a moron.
As to Mr. Hillygus and the competency evals, my ask today is either we find him competent based on the one eval.
God damn, Pope, what the hell?
His waiver as to the other one by refusing to meet with the first evaluator, or to dispense with competency proceedings because this court's belief or suspension of proceedings way back in 21, I think there's been material changes now and evidence we can rely on today to find that there is not doubt as to his competency. I would add, of course, that this is on the heels of the very first evaluators, 2 evaluators that this court set up in person, out of custody, that Roger Hillygus deliberately failed to appear and went on the run and was arrested in Missouri so many months later.
Brief response to what you said.
Okay.
Don't like either option. If we had both evaluations filed, we set it for a hearing for the state to traverse or emphasize or say there's been a change of circumstances.
Oh, really?
Sure. But we're one evaluation short. Now, I understand the state. Don't need it because the concept of competency is fluid. One may be competent to proceed to adjudication for moments in time, weeks in time, months in time, years in time, and be incompetent to proceed on either side. And it sounds like the state's position is, Judge, as of today, good to go. But let me tell you what the court's concern was way back when. remember, competency, legal competency under the statute, I believe 178-400, 3 prongs. Do they possess the ability to comprehend the nature of the criminal process against them?
All right, so now he's going through the elements for incompetency.
Do they understand the nature and purpose of court proceedings? And 3, and this is really the linchpin, at least from where the court's concern was at the time, and continues to be. Can they aid and assist with a reasonable degree of rational understanding in their defense, either with an attorney if they have one appointed, or if they've exercised their right under Ferretta to represent themselves, to assist themselves. And so it's really the reasonable degree of rational understanding. Really nothing has changed from the court. If anything, it's gotten a bit more concerning to the court that Mr. Hillygus in particular is struggling with that based on his beliefs, his views, his expressions, his body language, his demeanor, his approach. And so if we're going to have a hearing where you put somebody on the stand who says, you know, somebody can have certain beliefs and act on those beliefs, that's not an equal sign to legal incompetence.
Exactly.
That's an equal sign to somebody who's antisocial or has disparate views or
kinda
views that are a minority view, but nevertheless it's theirs, but that's not the same. But I don't think the court wasn't prepared to have that hearing this morning because I have one evaluation and even that one is a fail to engage. So that's where I'm leaving. I'll hear from you again in just a minute. Mr. Hillygus, I do need you to have a seat, sir. I realize you have things you want to say. You can whisper to your attorney.
Can I make an objection?
You cannot make an objection.
My beliefs or my rights?
Well, you can write these things down and flip it to Mr. Prasad and
Mr. Prasad has been terminated, he's been discharged, he's been withdrawn.
All right, well, I understand that was your effort or belief or hope, but at this point, he's still your
standby counsel.
To the extent the court has appointed him as standby for these competency proceedings. And I just want to emphasize, if we get through these competency proceedings, and if Mr. Hillygus is deemed to be legally competent, then I said it at the last hearing a month ago, likely either discharge Mr. Prasad completely or his role changes. But first things first. Mr. Prasad, based on the court's discussion with Mr. Steggy or anything he said, what say you?
I think that the court kind of touched on what I want to touch on, which is once competency proceedings have been initiated, and they were initiated by this court, is my understanding, I think the statute really requires those 2 evaluations to be conducted before we can move forward within the proceedings. So I understand everyone's frustration at the length of time it's taking, but I think by statute we really need to get that second eval.
Well, let's jump down the road then, because we talked at our last hearing about what the immediate future looks like after we have the evaluations. Let's suppose custody status changes or doesn't. Let's suppose he's evaluated in the near future, and let's suppose it looks a lot like the first one. Then I'm going to have an evidentiary hearing. The state's allowed to subpoena the evaluators, as is the defense, and I'll hear from them. And I'll make a determination whether Mr. Hillygus is legally competent to move forward in this case. And as I said before, if the court's determination results in a positive that he is, your role will likely be completely eliminated or changed to something peripheral, rather than a direct involvement in these competency proceedings. On the other hand, if the court determines that he's not competent to proceed to adjudication, then his case remains stayed. You can discuss with him whether you want to petition for a writ to have this court's decision reviewed by a higher tribunal. But then the case goes forward unless stayed as to Mr. Hanty. That's the way I'm looking at it. Any further thoughts? I'll hear again from Mr. Steggy.
I have no further thoughts related to that. Something I did just want to back up and touch upon. You mentioned this court has a desire to see a written bail motion potentially.
Well, something that outlines exactly where he would live, with who, make sure that the pretrial services has a current phone number for him, that he understands he would be on house arrest, understands what that means, understands that he would have to, at his own expense, engage in some type of a tracking unit to be on him to monitor his whereabouts, and play by the rules, you know, come into the courthouse once a week to meet with Mr. Meredith to check in, something like that.
Okay.
I mean, it doesn't have to be long, but this is our ask, Judge, and here's why you should do it. I'm already leaning that way. And if you followed it by Wednesday, so that Mr. Sticky could see it, he could either respond in writing on short notice or be prepared to argue it Thursday morning. I'm in trial next week and then off the following week, so I want to bottom this out with Mr. Hilligus's custody status by this Thursday morning.
So procedurally, Your Honor, I would just ask the court, since right now my office is appointed, as saying my constitutes competency issue, and then it's expanded to respond to the motion from the state related to jail communications. I think procedurally just to expand our appointment to.
Well, it's so expanded, so it now involves this as well.
Thank you.
But I'm not, you know, I'm cognizant of, you have other matters. This is probably something you may or even a date certain for hearing 9 o'clock Thursday. But if you file something that outlines what you're proposing, if it looks like what the court just identified and subject to concerns expressed by the state on why they believe that's a bad idea, and no guarantees, right? Thursday morning, the court might say, you know what, I've reflected on it further. I've heard from all parties. I'm not convinced this is going to make sure Mr. Hillygus is present for his evaluation, and all it does is set him up for another trip to the Midwest. I don't want that. I want to get him out of there so he can regain his strength and move forward with this case.
So the judge is kind of insistent that he get himself out of jail. The problem is that we're having issues with him following orders to attend evaluations, which is what the prosecutor's saying. So we're kind of in this in a stuck situation.
But yes, order that the standby counsel's scope of responsibility extends to pretrial service issues. Before I hear from Mr. Steggy, Mr. Silverberg, is there a position you'd like to advance on behalf of Mr. Ante?
Nothing related to the competency or the bail motion proposed hearing for Thursday, other than would our appearance be excused for any bail motion relating to Mr. Hillygus?
If that's the only thing on the agenda, yes.
Thank you.
You're welcome. All right. And still on the table for today, of course, is the commission meeting comments, and also, though, we're going to argue the other acts motion that the state had previously filed, to which Mr. Hanty's objected.
Sure.
So let's, and then, so Mr. Steggy, any final thoughts before I set a hearing for this Thursday and review Mr. Hillygus' custody status at that time?
Only confusion, because we set this hearing specifically to traverse. I said,
We have to traverse if we have all the evaluations done. We don't have those.
Okay, I would ask the court to make a specific finding of waiver, given that we have 3 evals that the defendant has deliberately failed to participate in. From there, the statute says the court shall suspend proceedings if doubt as to competency arises.
Yes.
That's the situation we're in now. Yet, the court, so confusion then, if proceedings are suspended, that we're going to a bail situation on Thursday, right? That's shocking to me, given, let's say he is incompetent, and he was incompetent when the court suspended proceedings, that caused him to, or within that context, the defendant fled. If he is incompetent, does not understand the nature of the proceedings, or it's really that last prong, which I'm confident Dr. Lauren will say that's volitional. There's a volitional act, whether he chooses to participate as with counsel or with the proceedings.
And that may carry the day.
And it should.
That may carry the day if I hear from two professionals.
But the idea that we should reward the defendant by, here we are jumping to Thursday to let the defendant out for his deliberate failure to participate in the proceeding.
So I think what the prosecutor's trying to say is that it feels like because Hillygus failed to attend or participate in the prior scheduled evaluations, it feels like we're rewarding him with release because he's been inside ever since he was arrested, which was last October. He was finally hooked up and extradited some time ago. And the prosecutor is saying, well, the only reason why he's still inside, right to this day, is because he hasn't been participating with the evals. So why are you in such a hurry to let him out? Because as a result of that, and the prosecutor's saying it feels like we're blinking, as it were. We're blinking, and so Hillygus gets to go released by virtue of him not participating.
Is a difficult pill to swallow for the state.
Well, the court
on the shortened.
let me say this, the court believes it either has inherent authority, notwithstanding the stay on the substantive matters with respect to this case, or it's ancillary. This is the court trying to find a path forward to make sure that the engagement with the evaluator is as meaningful as it can possibly be. And so if he's home or wherever Mr. Hillygus lives, maybe that inspires him, helps him, strengthens him to do the engagement. But I tell you this: the next time we set this for a hearing, the court will make, absent things out of the court's control, the court will make a determination as to Mr. Hillygus's competency. But the date I'm going to give you is not going to be for another 3 to 4 weeks, because I'm going to enter the order promptly, expanding or clarifying that it's in person, and giving time for that to happen, getting the report, and file it, and get subpoenas, and we'll set the competency hearing, and I'll make a determination at that time. I'm not going to continue to kick the can down the road if that's frustrating or that's the appearance, not the court's intention to. I was hopeful today would be that day. I understand the state wants it to be that day, but I'm not finding that there has been a waiver. No, I'm not.
And I do object to hearing without pleadings the question of bail on Thursday.
Well, if
it's wholly unrelated.
Okay, how much time do you need then to respond? I can
Let's
sit
come
there.
back in 3 to 4 weeks, because here's what I predict. Should the defendant be released, he will not participate in competency. Throughout his jail calls, he is refusing to participate in competency. Throughout his entire proceedings, he believes the entire process is illegitimate.
Exactly.
Is
the prosecutor's right. I agree with the prosecutor. He says he's saying, I predict the moment you get him out, he's not gonna do a damn thing. The court says he's not gonna participate in an evaluation. He's not going to follow any directives of the court, because he's already stated on record multiple times that he does not believe this court is legitimate. So the moment you release him, it's just he's either gonna run or he's not going to follow anything, any orders.
Hope would be misplaced to think that Mr. Hillygus.
So are you arguing that he's not competent because aid and assist with a reasonable degree of rational understanding?
No, I'm saying he is 100%. He is competent. He's competent because he has a long history of self-represented.
And so I agree. And so the judge is trying to say, well, is he incompetent or not? If you're saying that he's not going to follow directives of the court, and he's not going to, if he's not going to follow directives of the court, is he therefore incompetent? If I'm the prosecutor, it's like, no, I'm not saying he's incompetent. He's very competent. In other words, he knows what he's doing. My argument would be he's not incompetent, and he's about to say that he's had a history of self-representation. But my thing is, like, he knows what he's doing. He knows. And what I mean by that, Judge, is that he does not believe that you have any authority or any legitimacy. He does not respect this court's authority. Having a lack of respect of the court's authority does not inherently make one incompetent to stand trial.
Litigation. He's kind of an expert in per litigation. As to the third prong, his disparate, to borrow the court's views, his disparate views on the way the legal system works are not irrational. The hallmark of legal incompetency, 95% or more of people who are legally incompetent suffer from mental illness. It is a product of delusional thinking. Most often comes from schizophrenia.
Now, in fairness, what I would say sovereign citizen beliefs are irrational. Well, yeah, I still say they're irrational and delusional thinking. But I would posit this as an example to the judge. I would posit this as an example to the judge. Somebody can believe wholeheartedly that the earth is flat, but they could still understand right from wrong. They can still, steal. They can still commit homicide or manslaughter. Believing the earth is flat is absolutely irrational and delusional thinking. But he can still have the capacity to understand what's going on if he's charged with an offense. And the same goes with having a belief in pseudo-legal nonsense.
And related disorders. This defendant has no history of that, right? And so, as an example, and it's recognized within the field of forensic psychiatry and psychology, this idea of widely held but sort of fringe beliefs do not lead to incompetency. For example, we have related to the January 6th election, right? Those people hold widely held, non-delusional, but sort of fringe beliefs. They would be, if this was a case about that, 100% competent. But I don't, the overall picture I want to paint for the court for today is, if he's delaying competency and refusing to meet with multiple evaluators, a reward ought not to be he gets out of custody if as a product of that, right? If there's a medical issue, the first thing I'm going to ask this court for is a subpoena for medical records, because within this milieu of competency, malingering is a huge issue. This idea of secondary gain, actions for secondary gain.
If I ever hit 20K, I'll shave my beard.
Right,
that's how much I believe I'm not going to get to 20K.
Mr. Hankey already, he was in custody using a wheelchair, out of custody, miraculous recovery. I would want to attack that, and doing it by Thursday would not be, and I understand why the court's attention to this issue, right? But in broad strokes, to sort of spring it or to bring it forth now that it is frustrating that he won't participate with NAFCARE evaluators. It is frustrating that the public defender can't get someone to evaluate that person, but it ought not to punish, it ought not to go to the question of bail, it ought to go to let's efficiently solve this issue of competency.
In other cases, in other departments, some charges are being dropped against people because of delay of being evaluated, and then if a determination of being competent by the court that's not objected to, then to go to the treatment facility. Some say that delay is violating their constitutional or due process rights or some statutory rights, and the effect of that is cases are being dismissed.
Yeah, this is true. Wrongly, I would argue, and our Nevada Supreme Court is going to weigh in on that exact question the first week of June, because
we all need clarity.
Well, and the legal basis for that is there is no legal precedent in a criminal case to dismiss a case on, the Supreme Court has been not worried, the United States Supreme Court, on due process grounds. There's a case that's 300 days, and the United States Supreme Court not concerned.
Now they're talking about how long can a case go before the defense can make a motion to dismiss under the speedy trial protection.
About that, this idea that within due process, like speedy trial, flexibility sort of weighed in there and sort of weighing of interest. So we are hopeful for clarity, and we suspect it'll be in our direction. In any event, in this case, as a reward for deliberate delay, I'm uncomfortable having a bail hearing this Thursday.
Well, if Mr. Prasad by Wednesday files a short motion with an outline of what the conditions would be, how much time would the state need? And then I can set it possibly Tuesday of next week. I can start the jury trial a little later that morning.
I'm unconcerned about what the conditions would be. I'm most interested in this question of the threats made from in custody, the time, the reason for the flight, the long period that he stayed in flight in sort of fugitive status, and an explanation of him being the driver when Mr. Hanty was arrested on his bench warrant all around the same time this flight. So,
well, Mr. Hanty knows that he's had no direct contact or indirect contact with Mr. Hillygus while Mr. Hillygus remains on the competency proceeding status, and the same would be in Mr. Hillygus' direction for his custody status to change.
yeah. So if the court's
Deacon, thank you for the $20. Already about to talk to you how my mama talks to me while I'm going to school. Please don't take offense, but mom tells me you don't have to compare where you are from where you are going. Well, I appreciate the super chat. And the pep talk / advice. We'll see.
ask me what.
Well, that's a preview. That's a preview of the concerns, right?
Yeah, yeah. So if I had my druthers today, Your Honor, I would say set a status in 3 weeks on the, this would be the fourth person to try to evaluate the defendant. And from there, we can address the question of bail because, I mean, I'll point this out in any pleadings I do, which is it's meant to be an evidentiary hearing, and coming forth and sort of aspirationally saying whatever sort of he'll live, where he'll live, I think is of slight value in that analysis.
Thank you. Your Honor? Yes.
May I say something just very briefly?
Go ahead.
Because I know it gets Mr. Hanty upset, and I think the state does too. We are having a hearing on something that has absolutely nothing to do with Mr. Hanty, and the state still takes opportunities to jab at him, and then wonders in amazement when Mr. Hanty reacts. So what I would request is that the state be admonished, and there's no need for attacks on Mr. Hanty and his use of a wheelchair and things that aren't even relevant to this proceeding, other than to get under Mr. Hanty's skin. And that's the record I want to make.
He's being mean.
Noted. I don't believe the state has crossed the line, but I'll be more in tune to it on a go-forward basis.
Thank you, Your Honor.
You're welcome. Here's the order of the court then. Over the objection of the state, I'm going to have a hearing. It won't be this Thursday. That's too rushed. Tuesday of next week.
So Tuesday next week.
A week from tomorrow. Singular issue, Mr. Hillygus' custody status. Mr. Prasad, please, by close of business this Wednesday, file a motion to change status with whatever information you believe would be informative to the court. Mr. Stagey, at least one business day before the hearing, please file the state's response in writing. If any, you don't have to file a written response, you can merely argue. But if you want to put it in writing, please make sure I have at least a day before.
If I tender to the court a subpoena for the court's signature for medical records related to Mr. Hillygus for this limited purpose of bail,
I'm not likely to grant that request.
will the court sign a similar subpoena for this on the subject of competency for medical records as they relate to competency?
That decision I'll have to think about later because the competency hearing is going to be set. I'll give a date now, and I'll see what the next evaluation looks like. Then you can re-ask.
We do have Tuesday morning at 8:30 on Ham Jordan.
What is that?
That's the motion for joinder, followed by the motion probation revocation. that's it for me.
Okay, so 9 o'clock, please, on Tuesday. 9 o'clock next Tuesday, Mr. Hillygus, custody status hearing only. Now, I want to, go ahead.
I'm sorry, and our appearances wait for that.
It is.
Thank you.
Okay, so next week, next Tuesday, it's going to be a custody status hearing. In other words, it's going to be a motion as to whether or not Hillygus is going to remain in custody for the foreseeable future. So Hanty won't need to be there. They just waived his need for appearance. So that's what's going to be heard next Tuesday. Now the thing is, there's still about more than half of this hearing left to go. I have no idea what else they're going to talk about because they're not having the eval.
You're welcome. Now, I'm going to give a new date for a hearing for a competency hearing. The court fully intends to make a decision on whether Mr. Hillygus is deemed incompetent to proceed to adjudication, or is deemed competent. But not telling people how to do their jobs, but you need to be aware of what those two branches of the tree look like and what next steps would be. Because if the court finds Mr. Hillygus incompetent to proceed to adjudication, that's one direction, and if the court finds him competent to proceed to adjudication, then the question is, are we still go launch with both defendants for the August trial date? And of course, if he's deemed not competent, then whether there's going to be...
I'm probably going to be ending the stream in about
review.
8 minutes, so I'll
And
see
what
where the
happens to
cats
Mr.
are.
Hanty's part of the trial in August.
All right, sure.
So give some
He's right
thoughts
there.
of what that might look like. The court will as well try to be as familiar as it can with what the jurisprudence is in such circumstances. I will enter the order shortly that the interview of Mr. Hillygus shall be in person. Whether he's at the Washoe County Jail still or whether he's released somewhere else. The court is not available until the week of June what, please, Ms.?
June 12th, you have a trial set that week.
Give me just a moment.
The 8th might be an option. You said you would handle crimson, but you really How does Monday, June 12th look for counsel?
Your Honor,
All right, they don't want to be
they all know this week whether it's actually going to go.
they don't want to be picked up.
Of course, if
Oh, well.
it's related to competency, again, I would ask that our attorneys be ready.
Well, that's what it would be for.
I don't see any need for us for Mr. Hanty to be present at that hearing, and that way it can go forward timely without my trial calendar.
Thank you. Mr. Stakey, how's your availability?
It's fine. On that subject, though, should the defendant be found incompetent, we might want to hear from Mr.
Dracandros, think of the $2 Australian.
Counsel as to this question of the trial date, but I think we can, if that arises, we can quickly or timely schedule a hearing with Mr. Silverberg to address that.
Okay. So the 12th would work for the state.
Yes, thank you.
And how about Mr. Prasad?
I'm available until.
9 o'clock then on Monday, the 12th. of June, and that will be the competency hearing for Mr. Hillygus. Mr. Prasad, if there's any way for you to emphasize to your client, even though he has concerns with the entire process and the legal authority and all the other issues he's expressed and apparently continues to harbor, that if for some reason he's offered an opportunity at an evaluation between now and the 12th, the court's expecting him to engage to the best of his ability. All right, let's hit the pause button there. I want to slide over to Mr. Hanty's case.
Hey, Cap.
There's
In Virginia, think of it the 333.
mandamus, I believe, that the court continues to have under submission, continues to look at. The court does not have a decision yet, is working on it, and that should be out in the very near future. With respect to Mr. Hanty's recent engagement on April 25th at the Washoe County Commission hearing, and we're all aware, or probably aware, that the public comment piece is now at the end of the calendar as opposed to at the beginning, which I know has upset several people, but nevertheless, that was the decision of the new chairperson. It was brought to my attention some of the remarks Mr. Henty made at the hearing, including his frustrations with the district attorney's office, the Washoe County Sheriff, the Reno Police, and then he named 4 district court judges, Freeman, Riggs, Walker, and this court.
Uh-oh.
His tone was threatening. And unprofessional. Let me give you a couple examples.
Uh-oh.
Of the phrases he used.
So now it gets spicy. Now it's gonna get spicy.
Used in an extremely upset manner. Quoting, when the bell gets rung, all of you are gonna be put on notice. He also used the phrase, if it's the last thing I do, I will stop it, guaranteed, in referring to the injustice that he believes he and his co-defendant, Mr. Hillygus, are experiencing as part of this case. First Amendment right to
Persnickety, thank you for the $20.
express your views. It doesn't come without certain.
Thank you for the $20 tip.
Can't be threatening. Can't be made in a way that puts people in fear, reasonable fear of their safety. I know Mr. Hanty is frustrated. I know he is unhappy with many things, many agencies, many pieces of government, and of course the way different courts in this building have treated him. But this is unacceptable. This is unacceptable. The people are trying to do their job at the Washoe County Commission. If you have a problem with the way the case is being handled, you go through your attorney, he makes argument and legal briefs to the court. You lash out like this, you name judges, you say, if it's the last thing I do, I will stop it, guaranteed. If you say once the bell gets rung, all of you are going to be put on notice, not cool.
Not cool, bro. Totally not cool, bro.
Not cool. And I've already have in place restrictions on what you can do and talk about the pending case. Did you say the case name? No. Did you identify yourself and Mr. Hillygus as co-defendants? Yes.
Judge,
I mean, you did 3.5 weekends recently for being in contempt for the interview you gave on the blog, on the radio, and
which we also covered, actually.
you know, I tried to find a balance. Mr. Stagey asked me at that time, as I recall, to put you in jail for 30 days, I think, is the sanction.
Yeah.
The court went significantly under that. Now, does that mean it was a picnic for you to check in every Saturday morning till Sunday night?
So wait, so they said we did actually cover that in a later hearing of Hillygus having going on to some YouTube blogger or YouTube show and basically talk a whole bunch of BS about the judges and everything. And he was and the judge said that he was sentenced to 4 weekends in jail.
Of course not. Disruptive, embarrassing, upsetting, I get it. But the frustrations and the angst you feel, you have to find lawful respectful ways to release them, particularly when you're in a pending case and especially when there's a partial gag order here.
Yeah. So I think he also violated the gag order too. All right, Sean, thank you for becoming a member. I know I hate to do this, guys, but I really got to stop. I really have to end it here. I promise we will get right back into it with the next stream, but I have to stop here. I have a really bad headache. And about an hour was really all I could do for you. I didn't want to go AWOL again with for another week of not streaming. But I wanted to give you give an hour. I don't know if I'm going to be able to do tomorrow. I'm going to try and maybe do tomorrow for another hour. And then I probably give myself a break on Thursday and then go back to Friday and try and get myself back on my regular schedule. But I apologize to you guys, but I can't go. There's just been a lot of stuff in the background that's been going on. Thank you, Jadav, for your 23 months of support. I appreciate it. There's just a lot of stuff in the background with work and personal stuff, and yeah. But I want to thank you guys again. I hope that you guys have a good rest of your evening, and you take care of yourselves. And yeah, you have a good one. All right. Thanks, guys. As always, adios.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners. My bitch a chew